Good afternoon, everyone. If we could all start finding our seats so we can begin our final panel of the day. So welcome everyone to the Center for Worker Rights. Our panel today, we're going to be exploring some special interest influence, specifically labor unions, public sector labor unions, and we're also going to how that dovetails into life after Janus. And for those of you who don't know what Janus is, I think most of you probably do, but bear with me, we're going to give you a quick little overview before we introduce our featured speaker, Bill Messenger. All right, so for those of you who may have never heard the words Janus, I think, again, most of you probably have if you've been anywhere around Washington Policy Center in the past few years. But the Janus decision was a U.S. Supreme Court ruling on June 28th, 2018. It was really a landmark ruling, just absolutely precedent-setting. And it overturned a previous U.S. Supreme Court decision, what we would consider to be a bad decision that was made that allowed public sector unions to force government workers to pay union dues or agency fees. What the Supreme Court ruled in the Janus ruling was that that's a violation of their First Amendment rights. Forcing any government worker to pay a union due or an agency fee against their will for representation that many don't even want is an absolute violation of their First Amendment rights. And the reason is because everything a public sector union does is inherently political. If they are going to the legislature and asking lawmakers for a pay raise for government workers, or for smaller class sizes, or for whatever issue it is, that is in and of itself inherently political. The Supreme Court agreed, and they agreed. I should backtrack for 1 second because Mark Janus was the plaintiff in this case, and he's a child care specialist in Illinois. And so he was the one that brought this case, and they agreed with Mark Janus's argument and said, no, it is a violation of their First Amendment rights. And what's more, they went even further than we thought they might, and they said, you can't even force these workers to opt out, and which we'll talk about in a minute, which was sort of a strategy unions were adopting prior to Janus. But in order to collect those union dues or agency fees, it must be an affirmative opt-in. These workers must absolutely understand that they are waiving their First Amendment rights when they pay a union any agency fee or union dues to speak on their behalf. So really quickly, why should you care about Janus? If you're not a government employee, you don't work for government, why should you care? How does it impact you? Well, really, it really comes back to everything we do at WPC, to be honest, is impacted by the special interest influence of government unions in our state. I call it the cycle of special interest corruption, because what happens is you have these unions that have this guaranteed source of revenue. They don't have to work for it. They don't have to ask for it. It just regenerates and comes every year regardless. What that does, it allows them to, of course, spend an inordinate amount of money electing lawmakers and elected officials who are friendly to their cause, who will push a labor-friendly agenda that then continues to benefit those public sector unions. And really, it's created an unlevel playing field that has given public sector unions undue influence over policy and politics in Washington state. And just a little bit of history. When we started the Center for Worker Rights, it was really, it's a new center at WPC. We started it just a few years ago. And the reason we started is because we realized that all of these issues that we were talking about, at the time I was handling small business issues, but education, government reform, all of these issues, taxes, we found that there was a common denominator to those in opposition to the policy recommendations being put forth by Washington Policy Center. And that common denominator was public sector unions. So we sort of realized that, if you're ever going to make any real change, any significant inroads into improving Washington State, making it a better place to live and do business, we really have to address the issue of this special interest influence wielded by public sector unions. So we have the U.S. Supreme Court. They ruled in favor of Mark Janus in 2018. States and the unions, where they wasted no time. And actually, they started before the court even ruled in favor of Mark Janus. And so our response, now we're going to talk a little bit about what other states have done later, but I'm going to talk about Washington specifically. In 2018, what I call pre-Janus, our response to Janus, the court hadn't ruled yet, but public sector unions and the lawmakers they helped elect, they saw the writing was on the wall. It was fairly clear how the Supreme Court was likely going to come down on this decision. So they started working to sort of preemptively figure out ways around a Janus ruling. And so in 2018, our legislature passed a couple of laws. There were several that were out there. 2 of them ended up passing. One was they gave government unions 30 minutes of uninterrupted time during government workers' workday, so AKA the taxpayer dime, to sell them on the benefits of belonging to a union. The other bill they passed was they said, let's make all workers, government workers, union members by default. So as soon as you're hired, it's automatically assumed you're a union member unless and until you come and tell us you don't want to be, and you jump through all of the appropriate hoops that we're going to set up to opt out. Now, as you're going to hear in just a moment, it turns out that violates the Janus ruling, so it has, that law was actually invalidated because, as I mentioned a little bit ago, public workers can't be forced to opt out. That payment to those unions, it must be an affirmative opt-in on the part of the workers. So as you can imagine, our legislature was not really thrilled, lawmakers, to find out that a bill that they had worked quite diligently on was instantly invalidated by the U.S. Supreme Court ruling. In response, we had, and this was literally the day of the ruling, we had a comment from Senator Karen Kaiser, and she's the chair of the Senate Labor and Commerce Committee. And she said, quote, "There will be many new initiatives in 2019 addressing this Janus ruling." And she very well kept her promise, and there certainly were. So this year, in our 2019 legislative session, we had a suite of bills introduced designed to give unions a leg up in this, what I call again, the post-Janus world. The 2 bills that ended up surviving was a bill that makes it that allows unions to unionize even more of our state's government workers, so bringing more of them under that union umbrella, and a bill that makes it easier for unions to get that authorization, that opt-in that the Supreme Court said that they need to collect those union dues, and makes it much more difficult for workers to change their mind and quit paying those dues. So, and that bill is HB 1575. Essentially, it's really a grab bag of giveaways to the union, but in a nutshell, it accomplished a few things. One is workers can authorize the deduction of union dues, meaning they're opting in writing, plus by voice recording or electronically. Prior to that, it was only in writing. Now what they're saying is, hey, you can do it over a phone call. Well, you can imagine the concerns we have with that. I doubt the union is going to record the entire phone call, so who knows what they're going to say. What the union will do is have an unrecorded conversation with a worker. They will then say, state your name and say yes if you agree. That's where they'll hit record. And that's what they will then use to authorize as the authorization to collect those dues. These are long and lengthy contracts. They're over 2,000 words. There's some complex language in them. And really, there's a lot of language in there that significantly restricts their ability to ever quit paying the union, and sets up a series of hurdles and obstacles that they have to navigate in order to do so. So it's very concerning that unions can now do this, but we thought, hey, you know what, if you're going to do this, well, actually, you know what, I'm jumping ahead. I'll talk about that in a second. The workers can only reverse that authorization in writing. So there's your first double standard right there that we had, and I'm going to talk about that in just a second. And interestingly, During the committee testimony, when lawmakers asked, well, why would you have one and not the other? Shouldn't the standard be the same? If the standard is electronically or via telephone, voice recording, shouldn't that be the same standard to opt out, to quit paying the union? And really the union representatives testifying, they had no answer. Their only response was, well, there could be some fraud that goes on with that. So you can imagine some of the laughter in the room of, okay, well, how does that, amongst some of the conservative lawmakers of, okay, how are you not applying that to the standard here? Only the union can direct the employer to quit deducting union dues. So what this means is if you're a worker, you told the union you don't want to pay them, or in your opinion you have, it doesn't matter. Only the union can tell the employer to quit deducting those union dues. You can go to your employer and say, I didn't authorize this, I don't want this, I do not want to pay them, and all the employer can do, and this is a government employer, is say, talk to your union. It puts the entire battle in the lap of the worker, an individual worker taking on the bureaucracy of their public sector union to try to accomplish their goal of keeping more of their paycheck. It also eliminates unions' legal liability under state law for illegally collecting dues from public workers. It strips public workers of their ability to vote on union representation in secret ballot elections, which, you know what, we all hold our elections in secret. We get our ballots where they're closely guarded when they're mailed to us, when we mail them back, if we go to a voting booth. So you would argue that the same standard should be applied to workers who are voting on whether they want a union to represent them. But this bill has stripped them of those secret ballot elections in favor of something that they call cross-check. And what that does is it basically allows union reps to go to workers one-on-one, confront them at work, at their home, wherever it may be, and say, hey, we want you to sign this card. We want you to sign this card that is a showing of interest. And the second part of what the bill did as it relates to authorizing unions, certifying unions, is it lowers the threshold. The showing of interest used to be set at 70% of workers, and this bill lowered it to 50. So not only are they stripped of their right to vote in private and be free, not be subject to harassment, intimidation, any sort of being ostracized publicly by their colleagues or by union representatives, but it also lowers the threshold and makes it much, much easier for those workers to be unionized. The bill passed along a party line vote. There were over a dozen amendments that were offered by lawmakers on the other side of the aisle that sought to remove some of the most egregious portions of the bill. And I just listed a few of them. There were, like I said, I think there were about 14 of them, but one would have been allow the workers the same means to cancel dues as they used to authorize. Again, it makes sense. Union reps had no coherent justification for such a double standard. But that amendment failed. Government employers could only deduct union dues if the worker has affirmatively acknowledged or waived in writing their constitutional right to not pay the union, meaning you're getting that affirmative opt-in. You are getting something in writing that the worker is acknowledging that they are waiving their First Amendment rights by agreeing to pay the union to represent them. And that amendment failed. An amendment requiring government employers to initiate or cease dues deduction at the direction of the worker instead of the union. That amendment failed. An amendment that would have required government employers to receive an indemnification agreement before collecting dues. What those lawmakers were concerned about is, hey, if the employer is deducting these dues, we could be opening our government agencies up to liability if something has not been done properly, or if it turns out that those union dues are not being collected appropriately. That amendment failed. An amendment that would have removed the language requiring government employers that only process dues deductions, cancellations in accordance with union policies. Removing that language, that failed. And what that would have done is it would have stripped some language out of the bill that basically bolsters unions' authorization and deauthorization policies. And what those policies are essentially are very, very restrictive, limiting to usually about 10 days a year that a worker can opt out, can quit paying the union, and they have to then reaffirm that opt-out each and every year during that same 10-day window. That amendment failed, and an amendment that would have required dues, deduction, authorizations, and cancelizations to be submitted to the public employer, not the union. That amendment failed. Again, all along a party line vote, except for, I will say, there was one Democrat, the Democrat Senator Tim Sheldon, as usual, voted on the side of worker rights on this bill. But one surprise holdout was a Democrat Senator Bob Hasagawa, who is typically very friendly to unions. And one might think that he was enlightened and decided to stand on the side of worker rights and worker choice and uphold the U.S. Supreme Court decision in Janus. But no, the reality was he was making a philosophical stand, showing his opposition to any language that even acknowledges the Janus ruling and removes that language that forces those workers to pay those compulsory union dues. So in his mind, the bill it didn't go far enough. So the question is 1575 unconstitutional? WPC's perspective is that, any restrictions, especially these ones in 1575, on how and when a worker can exercise their Janus rights is really as much a violation of their First Amendment rights as forcing them to pay, as compulsory unionism. This point was brought up during some of the very heated discussions in the legislature. And it was interesting. It was actually a little bit surprising. One of the Democrat lawmakers said, no, it's not in our purview to make those decisions. The legislature is not the venue where we determine constitutionality. It happens across the parking lot in the Washington State Supreme Court. So in other words, who cares if we don't care if it's constitutional. That's the workers' problem. Let them take it to the state Supreme Court. And to which one Republican lawmaker shot back, it is incumbent upon lawmakers to refrain from doing what may be unconstitutional. So that really gets to sort of the heart of 1575 and really the difference in philosophy between the two sides, the party line vote of how they view worker rights and the role of lawmakers. So the question is 1575 unconstitutional? And at least one organization in our state, the Freedom Foundation, they're very active in litigating against public sector unions. They say it is, they believe it is, we believe it is, and they have already signaled their intent to challenge the law in court. But we're really lucky today because we have with us our featured speaker, Bill Messenger, and he can give us a little bit more insight into 1575, his opinion as to whether it is unconstitutional, and he's also going to give us a little bit of an overview beyond Washington State, what's happening in other states, because believe it or not, some other states are going farther than Washington. In Oregon, there was a proposal that the government would make up the difference of union dues and agency fees. So in other words, what they would do is the government would pay the union those agency fees, and then they would simply lower each worker's pay by that amount. So as you can imagine, that encouraged quite a bit of criticism and quite the controversy and debate. It didn't pass, but that's not the only state where this idea has been floated. So this is not an idea that they think is off the reservation, because lawmakers in other states are talking about doing it as well. But our speaker, Bill Messenger, he's going to be able to give us a little bit of a better idea of what's happening in other states and sort of a look into the future, into what I sort of call Janus 2.0. What can we expect in the future? What might be the next big lawsuit, the big litigation or case that takes us one step closer to achieving real freedom of choice for our state's workers, for our country's workers? And if there's one man who knows this issue, it would be Bill Messenger, because he is the man that argued the Janus case and won before the U.S. Supreme Court. He also argued the case several years before that accomplished a similar end result as Janus, but it applied to only a narrow segment of home health care workers. And that case was called Harris v. Quinn. And he argued that before the U.S. Supreme Court. So he has two significant victories under his belt. And so we're very lucky today to have him here to sort of give us an overview, give us his thoughts on HB 1575 and whether he thinks what our legislature did is unconstitutional and what the future might hold in this really bizarre post-Janus world. So please welcome me and join me in welcoming Bill Messenger. And I should probably mention he is the staff attorney for the National Right to Work Legal Defense Foundation.
Thank you, Erin, and thank you for having me out at the event today. I have to admit I've been sort of scrambling of thinking what I'm going to say since I saw that video you made at lunch about what Janus held, because that pretty much sums everything up a lot more cogently than I ever could. It's probably the first time I've ever been upstaged by a cartoon. May not be the last. But Janus is very straightforward. It's about worker freedom of choice to choose whether or not they want to support a union or not. Under Janus, no worker could be compelled to support a union against their will. And as the video indicated, its legal basis is also very straightforward. The First Amendment guarantees every citizen a right to choose what advocacy group they support, whether it's the Democratic Party, Republican Party, Washington Policy Center, Sierra Club. You have the freedom to choose. The government cannot force you to support any advocacy group. And a public sector union epitomizes a political advocacy group. Its function is literally to try to influence the government on behalf of a given group of individuals. It is effectively a mandatory government lobbyist. And it's somewhat surprising it did take the Supreme Court over 50 years to realize that it is unconstitutional to force public employees to support a union advocate. But finally they did in Janus in June of last year. Now the story of how we led up to Janus is actually somewhat interesting. It was the culmination of a 50-year legal battle, primarily by the Right to Work Foundation. But seeing many familiar faces, in this room, you've already heard me tell that story or you've heard it in the past. So today I want to focus on what's going on right now and what we're looking at in the future under Janus. I want to break it into 4 areas. The first is the current impact of Janus. The second is obtaining retroactive relief under Janus for people whose rights were violated before the decision. The third is enforcing Janus prospectively, mainly against escape periods, like Erin just talked about under HB 1575. And then potentially expanding Janus to new areas, such as to exclusive union representation and perhaps to the private sector. But first, let's talk what is the impact of Janus. Now, this is what we know currently. Prior to Janus, based on the federal government's BLS survey, there were over 5 million public employees who were working in forced unionism states. So you have about 5 million public employees who were being forced to pay union dues, whether they wanted to or not. Of that, about 8% were compulsory fee payers, or agency fee payers, who didn't opt to join the union. After Janus was decided, all 5 million of those public employees now have a First Amendment right to choose whether or not they want to support a union. And of that 8%, or about 400,000 individuals, the union stopped taking their money almost right after the decision came out. Because Janus was so unequivocal, they knew they didn't really have much of a choice in the matter. And some of the union's filings with the federal government sort of confirm those findings. So for example, AFSCME and the SEIU recently filed reports to the federal government that suggested they lost about 210,000 agency fee payers after Janus. Most of the teacher unions don't file such reports, but if you assume similar numbers amongst them, it probably puts you around about the 400,000 range. But now what we don't know, we do know that the unions lost all their agency fee payers, but we don't know how many people decided to drop their union membership after Janus. I mean, doubtlessly a lot of people, public school teachers, state employees, only joined the union because they didn't really have much of a choice. Their choice was join the union and pay full union dues, or pay 90% of full union dues and don't be a member. Well, if you're paying 90%, you might as well join the club. So how many individuals are going to drop now that they have the right to choose? And the answer is we don't really know yet. At least with respect to AFSCME and SEIU, their membership numbers haven't changed much with their federal filings. And with the teacher unions, we don't really know, because again, they don't systematically file. You only have anecdotal evidence. So to speculate, what does that potentially mean? Don't know. The unions say, well, that just shows that union members really wanted to be union members. It wasn't because of the forced dues requirements. However, others could say that, well, a lot of states are forcing individuals or restricting their rights to get out of the union, and that's why you're not seeing a drop in union membership. The unions also engaged in very aggressive membership campaigns during the year Janus was decided because they knew they were most likely going to lose. So basically, we're going to have to wait and see over time what effect Janus has on union membership numbers. But all we can know is that the forced fee payers, have been freed as a result of the decision. So switching gears to retroactive relief under Janus. Supreme Court decisions are almost automatically retroactive under a case called Harper decided in the 1990s. And this makes sense. And the reason is when the Supreme Court says what the First Amendment means, it's not creating a new First Amendment right. It's saying what the First Amendment has always said. So when the court said in Janus it's unconstitutional to take an employee's money against their will under the First Amendment, it's always been unconstitutional, not just from June of 2018 forward. And so what that means is employees whose rights were violated before the Janus decision can file suits, and they have, to seek the dues that were taken from them in the past. Now, they can't go back 40 years because of the statute of limitations, which generally run about 2 or 3 years. It varies by state. But right now, there's about 48 lawsuits pending all across the nation seeking to claw back the monies the unions took from agency fee payers prior to Janus. Most are filed as class actions, and the relief sought in these cases is considerable. And generally speaking, the unions are raising the same defense in almost every case. They call it a good faith defense. And the argument is basically, they had a good faith belief it was legal to take their money, these employees' money at the time, therefore they don't have to give it back. Now that's somewhat counterintuitive. If you take someone's property accidentally, even with a good faith belief, and it winds up actually it wasn't yours, generally you have to give it back. You don't get to keep it because you made an honest mistake. But the unions are arguing that basically a good faith mistake of the law allows them to keep the money. And unfortunately, at the district court level, the unions are prevailing on that argument. District courts in California, Oregon, Washington, Connecticut, and Illinois have now accepted the union's good faith defense to having to return these fees. However, that's just the first round of the battle. Now all of these cases are moving their way up to the appellate courts, to the Ninth Circuit, to the Seventh Circuit, to other circuits. And ultimately that issue will be decided by the appellate courts or potentially by the Supreme Court, which has actually reserved this good faith defense issue in 2 prior cases, but said we don't need to decide it here, which suggests that one day they may ultimately decide that issue. So long story short is we don't know how these cases are going to turn out, but one interesting thing to add is that because the unions are raising the same defense in just about every case, and because this is working its way up the legal food chain, there's a decent chance of an all or nothing decision. Let's say the Supreme Court takes the case and says, yes, there is a good faith defense. All these cases fail. On the other hand, the Supreme Court takes cases, no, there's no such thing as a good faith defense to a First Amendment violation. Then all these cases could succeed across the board, and the recovery against the unions could be rather considerable. But we'll see how that plays out over the next 1 to 3 years, is my estimate. So the next issue is enforcing Janus prospectively. And this brings up a lot of what Erin talked about under HB 1575. The main way that unions are trying to resist Janus is with escape periods on dues deductions. And what they're saying is that for employees who authorized payroll deduction in the past, which means they agreed to have union dues deducted in the past, they can only revoke that authorization during 10 or 15 days of every year, which means that for 355 to 360 days of the year, they can't enforce their rights under Janus. You can only get out during these escape periods. Now, how do they justify that? And the answer is they put it in the dues deduction agreements or in the collective bargaining agreements. So the dues deduction card signed in the past would say, I authorize the deduction of union dues, and I can only revoke this during one 15-day period per year, otherwise it's irrevocable. Sometimes it was in contracts. In Pennsylvania, Ohio, and to some extent in California, you had maintenance and membership provisions which said dues deduction can only be canceled during one period per collective bargaining agreement. So that's one 15 or 30-day period every 3 years, which is the normal term of a contract. Now, the argument is that this violates individuals' First Amendment rights under Janus. There's currently about 36 lawsuits pending challenging these escape periods. And these cases all hinge on the second to last paragraph of Janus, which is arguably the most important paragraph of the decision. And what the paragraph says is, the government cannot deduct dues from an individual without their affirmative consent. And that affirmative consent has to meet the criteria of a waiver of First Amendment rights. Now, a waiver of First Amendment rights, there's a ton of law of what constitutes a waiver of constitutional rights. It's a very high standard. A waiver has to be knowing, voluntary, and intelligently made, and not against public policy. And the reality is that union dues deduction agreements come nowhere close to meeting the requirements of a constitutional waiver. And that's particularly true of those signed before Janus was decided. How can you say an individual knowingly waived their rights under Janus before the decision even came out? How could you say their dues deduction agreement was voluntary when at that time they didn't really have much of a choice, because they were going to be forced to pay dues whether they wanted to or not? So the argument is that these restrictions, these escape periods on revoking dues deductions violate that paragraph of Janus because they don't amount to a waiver. Now, the union's argument in response, because I think they realize they can't show a waiver, is that they're trying to get courts to basically construe that paragraph in Janus into non-existence. And they make two arguments. One is they say, well, Janus only requires a waiver if you deduct union dues from a non-member's wages. But if an individual is a union member, no waiver is required, a contract's good enough. And the second argument is that the First Amendment doesn't even apply to government dues deduction. That government dues deduction is merely a private agreement between an employee and a union, and therefore there is no state action, and the First Amendment doesn't apply, even though it's literally the government taking the individual's money from their wages and giving it to the union, and the fact that Janus involved government dues deduction. However, a district court judge in Washington accepted that argument in a case called Belgao and held there is no state action with state dues deduction. That case is currently before the Ninth Circuit. Most of these other cases are in their infancy before the district court level and aren't at appellate courts. As far as I know, Belgao, the decision I referenced before, is the only case at an appellate court. The rest are at district court levels, most of which in California or Washington. What we're finding is that in other states, particularly in the Midwest, unions are folding. Individuals challenging, for example, the maintenance of membership provisions that you can only get out during one contract or one period per contract. The unions are just giving up and saying, we're rescinding that. And then they rescind it, and then they come up with a new policy that's not as bad, and then you have to find somebody to challenge that, sort of playing a little game of legal whack-a-mole. But this will be the litigation battle in Janus, I think the most important one, going over the next couple of years. This will probably take longer than the good faith fight, just because of the time frames involved, because these cases are more in their infancy. But arguably, it's the most important. Can individuals exercise their First Amendment rights under Janus at any time? Or can unions pretty much put whatever restriction they want on when individuals can get out? And that brings to a second subsidiary issue that unions and states have turned to undermine Janus, and that's compulsory union orientations. And the idea here is that they try to get new hires as part of the new hire process, that you have to attend a mandatory orientation with the union, whose main goal is to get an individual to sign one of these dues deduction cards that they can't revoke. We first saw this with respect to the Medicaid and home health care providers. Now, these are individuals that almost always work in their own homes. Usually, their parents taking care of their own children and receiving a Medicaid payment for so doing. The states, California, Illinois, are basically forcing them to show up to mandatory once-a-year trainings, of which 30 minutes is literally a union indoctrination meeting, in which they try to browbeat them to support the union and convince them to sign one of these cards, which they can't get out of. Now, currently, there are no lawsuits challenging these, just because it's somewhat hard to set up. But there was one in Washington State, and it dealt with home health care providers. And what the union did there, it folded. There was a mandatory orientation they had to attend. The union and state of Washington said, fine, it'll no longer be mandatory, therefore the case is moot, and the district court agreed and dismissed the case. The problem, though, is that the state and union don't tell people it's voluntary and that they can leave. They believe they actually have to sit there through the 30-minute part of their training that involves the union trying to get them to sign a dues deduction card. However, there will be future challenges to this, because in my opinion, this violates the First Amendment. Since when can the government force a citizen to attend a meeting with an interest group? Could the state of Washington say every public employee has to spend 30 minutes with the Democratic Party to get them to convince them to sign up and deduct dues to the Democratic Party and campaign for them? Of course not. And I think the same should apply to unions, and I expect that litigation to happen in the future, but again, right now, there are no pending cases. So those are cases to enforce Janus, which is a big litigation battle in and of itself. And then the final category is extending Janus to new areas. And there's really two areas: the private sector and exclusive representation. Let's just take them in reverse order. So exclusive representation is when the government gives the union the right to speak for all employees in a bargain unit, whether they like it or not. So if you're a teacher represented by the WEA, you don't have any right to speak for yourself vis-a-vis your employer. You have no right to contract for yourself. The union has the exclusive right to speak and contract on your behalf over subjects of bargaining, whether you like it or not. And so the argument is that under Janus, if it violates the First Amendment to force you to pay this government-appointed advocate, why can the government even force you to accept an exclusive representative in the first place? Doesn't this too infringe on your First Amendment right of free association? Well, there's a number of cases challenging that pending nationwide. Some are at district courts. Unfortunately, however, the Supreme Court in two recent decisions decided not to take two cases. One of which was one of my cases. The case was called Bierman. That challenged whether or not the government, or state of Minnesota, could force healthcare providers there to accept an exclusive representative. On Monday, the Supreme Court decided it wouldn't take the case. There was also another cert petition that was denied in a case called Uradnik about a month before that. However, with the Supreme Court, you never know exactly why it wants to take a certain case or not. All you can keep doing is knocking at the door, and then hopefully one day they open it. Either that or you just keep knocking on the door for the rest of your life. So there are other cases working their way up there. Probably the next one to reach the court is out of Washington State. It's called Mentel. I believe it will now be called Miller. And in that case, the issue is, can Washington force child care providers to accept an exclusive representative? Now, a family child care provider, not only are they not state employees, they're small businesses. These are individuals who run daycare businesses out of their own homes, and for some children, they receive state reimbursement for taking care of that child. Basically, the state has a child care program that subsidizes child care for low-income children. The state of Washington declared them to be public employees solely for purposes of unionization and appointed a union to speak for them with respect to child care policies that affect them. We, and also with the Freedom Foundation, filed a litigation challenging that. The Ninth Circuit said there's no problem, that doesn't violate the First Amendment. We will now be bringing that case to the Supreme Court. It'll be filed in about a month, and the court will decide whether or not to take it in October. So that's the next exclusive rep challenge the court will see. And then the final topic I want to touch on is the private sector. Janus, by its terms, only applies to public sector employees if you work for the government. Janus reserved the question of whether or not it applies to private sector employees, i.e. if you work for a private sector company. And the big distinction between the two, and this will be the subject of future litigation, is there state action in the private sector? So only the government can violate an individual's First Amendment rights. A private company couldn't do it even if it wants to. There needs to be what's called state action. And under the federal labor laws that govern the private sector, the federal laws don't require an employer to enter into a compulsory unionism agreement. They only require that it be bargained over, but they don't technically force it. So is that enough to show state action? Is that enough to show that the government's hand is behind that compulsory fee requirement? The circuit courts have reached different opinions on that. Some have said yes, some have said no, all in cases that came well before Janus. These are going back the 70s, if not earlier. So most likely there will be litigation in the future of whether or not Janus can be extended, to private sector employees, and also give them the freedom to choose whether or not to join or support a union. I'm only aware of one case pending on that right now. It's a case in New Jersey dealing with airline attendants. for United Airlines are mechanics, either airline attendants or mechanics. But with United Airlines in New Jersey, again, that's just at the district court level. But in sort of the longer term, I'd expect to see litigation over that. So those are sort of your main areas of Janus litigation: retroactive relief, enforcing the decision, and extending it. And then we finally want to close with sort of what's a third wheel. It actually has nothing to do with Janus, but it's something you may be interested in because it does deal with compulsory union fees. And that's recently, the federal government recently issued a rule that it's now illegal under federal law for states to deduct union dues from Medicaid providers. So these are the home health care providers that were issued in Harris, and in other cases, these are individuals who aren't state employees who receive Medicaid payments, but nonetheless are were before Harris forced to pay union dues, and now the unions are doing what they can to siphon dues out of them through payroll deduction. That should have always violated federal Medicaid law. There's a section of that law, Section 32, which says that all Medicaid payments must be made to the provider of the service and cannot be sent to any other person, including by an assignment. Now, of course, that's exactly what Washington and California and all the rest of those states have been doing for a long time, diverting Medicaid payments owed to providers of services to the SEIU usually by means of an assignment. Well, the Trump administration finally got around to amending its rule, issued its rule about 2 weeks ago, in which clarified, yes, that violates federal law. States have to stop those payroll deductions. However, sure as clockwork, Monday of this week, the Attorney Generals of California, Washington, Connecticut, and a couple other states filed a lawsuit saying, basically seeking to enjoin that rule, saying it violates the Administrative Procedures Act, and that stopping them from diverting Medicaid payments to the SEIU would somehow undermine their Medicaid payments. That was just filed with the Northern District of California on Monday, so expect litigation over that, of whether or not that rule will be enforced. What's interesting, the news story I read about it said that it's now the 50th case the California's Attorney General has now filed against the Trump administration to stop them from implementing a new rule. So the Medicaid rule is now number 50, but it is very significant. They're taking a great deal of money from tens of thousands of Medicaid providers through this. If those payroll deductions stopped, that would be a very significant improvement in the law. So again, we'll see how that plays out over the next year or two. So with that, I'd like to open it up for any questions anyone may have.
Oh, hold on 1 second. He's going to walk up with the microphone so everyone can hear your question.
Is the opt-in, opt-out provision only for new hires, or is that for existing employees?
So opt-in is now the law of the land. So prior to Janus, there was case law that supported the idea that if an individual didn't want the union to take their money, they needed to affirmatively object. They needed to opt out. Otherwise, the default was the union just took their money. That's what happened to Mark Janus. We brought that issue to the Supreme Court. We argued the court should make clear in Janus that's not permissible, and they did that. And very simply said, government may not deduct any monies, nor may a union collect any monies unless the individual affirmatively consents to pay. And that affirmative consent has to meet the waiver requirements. So now everyone has to opt in. The big question, though, is what about individuals who arguably opted in prior to Janus, who signed these dues deduction agreements with the windows? Does that constitute a valid opt-in, or is that valid consent? We argue it's not, because it doesn't satisfy the criteria of First Amendment waiver. The unions in the state of Washington and other states say good enough. So opt-in is the law of the land, but how much of an opt-in is required is now the big fight. It's a way to conceptualize it.
Do you have any other questions? But and while we're thinking, I see one back there, and while we're heading there with the microphone, I just want to point out what Bill mentioned about the dues loss from the new Trump administration rule change on the Medicaid siphoning of Medicaid funds to SEIU. That represents $27 million approximately in Washington state alone. So those in-home caregivers, most of whom, as Bill mentioned, are caring for a family member in the home, usually parents caring for a disabled child or such. And those funds are automatically taken from their paycheck, sent to the union before the caretaker ever even sees their paycheck. And that amounts to about $27 million a year for SEIU. So you can imagine how frantic SEIU and the elected officials and policymakers that SEIU has helped put in office, how worrisome that is to them.
To add another number, in California, one SEIU local alone with home care providers, its revenue is over $70 million a year, almost all of which is from those Medicaid providers. So it's real money.
So in parallel to this effort that's going on in the courts and policy and legally, can you comment on the changes in social attitude about unions, the role of unions in our society and economy over the decade? And it just seems that they're less popular and less relevant, and that if people don't see union membership as being useful, as maybe was the case in the 1970s or the 1950s, that there's just a general attitude decline in whether unions are still useful.
I think the numbers bear that out. Right now, only about 6% of private sector employees choose union representation. So 94%, don't want a union. It's not like the unions aren't trying to organize as many people, as they can. So that shows a profound shift in union popularity, because I forget the high water mark going back to the 50s or 60s, but it was well over 30%. I forget the exact number in the private sector. Now in the public sector, it's a more recent phenomenon. Public sector employees, believe it or not, weren't really unionized before the 1960s. It's hard even to envision now, but started in 1959 in Wisconsin and spread from there. The union density there is still relatively strong. It's well over 30%. So I can't say whether public employees' attitudes have changed, but I think certainly public attitudes towards public sector unions have changed. And you can especially see that, with our luncheon speaker today, Mr. Walker, Governor Walker, of what he started in 2010 and 2011, and that many taxpayers and people of the state saw the public sector unions as the problem, that was holding back their school districts or their cities, and you can certainly see that opinion across the board, and also in the fact their political activities. When compulsory fees in the public sector were first upheld in 1977 in Abu, the court said, well, this is just like private sector bargaining. It's not that different. It's over wages and benefits. Well, as the court mentioned in Janus and also in Harris, by the aughts, by 2014 then 2018, there could be no question that public sector unions are a political organization. In many states, they are the political heavyweight, and I think that almost no one now is blind to that on either side of the aisle.
I have a quick question for you. So, as we get the microphone to the next question, real quick. So, what are your thoughts on 1575? I mean, unconstitutional? Are there provisions in there that you think are unconstitutional that are should be challenged?
I believe so, especially unconstitutional as applied. So, basically, what 1575 does, and this is what they're doing in a lot of places now, they're giving all the authority over dues deduction to the union. And what it's saying is the public employer has to automatically deduct dues from whoever the union says deduct dues from. So if you revoke, you have to go through the union. The union decides what's on the cards. The union says whether or not that individual validly signed the card or agreed to it over the phone or whatever. And so they're trying to transfer the responsibility there away from the state. The thing is, though, is that Janus was about government dues deduction. That was the key to the case. That's the underlying First Amendment violation. The state of Illinois was taking an individual's money and giving it to a SEIU to support its speech. That's the violation. And so too in Washington State. It's the public employer deducting the dues that is the violation if there's not consent. Therefore, it's incumbent on the public employer to show that there is consent to dues deduction and whether or not they revoked it. And a public employer can't shirk that duty just by saying, we'll trust the union, or to say, I'm just following union orders. So for example, let's say an individual never agreed to dues deduction, but the union said take his money anyways. The government can't say, hey, the union said it was okay, so it's not my responsibility on violating his First Amendment rights. Yes, it is. The First Amendment applies to the state and to public employers. they have the responsibility not to take anybody's money for union speech without proper proof of consent. And Washington's attempt to try to basically remove the state's responsibility and throw it on the union, I think, is unconstitutional.
I think it's interesting that lawmakers refuse to, Democrat lawmakers, refuse to pass an amendment that would have indemnified government employers, that would have forced government employers to obtain an indemnification agreement from unions for collecting those dues. So government employers are on the hook and liable.
Just one line of cases that I just wanted your opinion on is the state bar associations and the difference between the mandatory versus voluntary bar associations. I know there's been some litigation on that front. I think you were actually asked about this by Justice Ginsburg in oral argument, and I think you said you did feel like states would have a compelling state interest in maintaining mandatory bar associations. And then my second question is, in oral argument, was there a point that you thought, you know what, I think I might win this?
On the first question, the case is called Fleck versus Wetch, is the lead case. The Eighth Circuit Court of Appeals, which is based in Minnesota, just scheduled oral argument for June 13th. So the issue in Fleck is whether or not mandatory bar fees are unconstitutional. Because before, there were only really two groups in America that were forced to support advocacy groups against their will: public employees and lawyers. And so now people are challenging the bar fees. There's other bar fee cases at the lower courts. But Fleck was remanded by the Supreme Court back to the Eighth Circuit, told the Eighth Circuit, rethink your decision in light of Janus, and the court is currently doing that. So oral argument, I want to say June 13th, but that might be give or take a few days. So that issue is coming up to the court. And then in terms of the Supreme Court, so it was difficult to tell. So most likely, because of prior decisions, Justice Gorsuch was swing vote. Because in Harris, 4 of the justices voted one way, 4 of the justices voted another way about whether or not it was constitutional to force home health care providers to pay union dues. In Friedrichs versus California Teachers Association, the court also split 4-4. The missing justice was Justice Scalia, who passed after Friedrichs was argued. So the only person who hadn't voted on the validity of compulsory union fees prior to Janus was Justice Gorsuch. At oral argument, Justice Gorsuch decided to say absolutely nothing. And it was deliberate. He's not, he's usually very active at oral argument, and he said absolutely nothing. So at the end of that argument, everyone could only be left guessing how he would ultimately rule. Obviously, he ruled with the majority, thankfully. So until the day of the decision, we never really knew. If he would have said something, that certainly would have been, you know, yes or no for one side or another, but he didn't remain silent.
Do we have any more questions?
This is probably a question for you, Erin. How many public employees are there in unions in Washington State? So, and this average union due is about $1,500. Like, what's the total dollars in union dues?
Yeah, the average dues are around $600 a year. They can be as high as you know, $1,100, $1,300. Every union is different. Some charge 1.2% of wages. Others charge, you know, higher, 2.3% or such. And as far as, you know, I mean, state employees alone, the number is significant. Home health care workers, you've got around 40,000 represented by SEIU. State workers alone, you've got a little bit more than 40,000. And that's not even that's not including, you know, the unions representing. You know, I'm sorry, what? The number I've heard is around probably about 150,000. That's, you know, that's difficult to gauge sometimes because we rely on reports, and public sector unions do not have to provide the same reports that private sector unions have to, that provide all of the same information. So it's sort of cobbling together some numbers, and so there are some discrepancies on what some people say, what some groups have sort of come up with, and others. But that's sort of a ballpark.
wondering is whether this opens up, you know, since this is basically a question of speech, whether this opens up the possibility of multiple unions representing a particular group of workers. So perhaps a liberal and a conservative union. Is that a possibility?
I would say it's a possibility only if the court eventually strikes down exclusive representation. So exclusive representation, the name implies it's monopoly representation. There is only one union, like the Highlander. However, if the court was to say you can't have exclusive representation, individuals can choose which union they want to represent them, then you may have a multiple union situation. Also note that other countries do have different labor systems that don't rely on monopoly representation. There are more than one union. So there are other labor models like that. Nothing would stop a state from potentially trying that, but generally speaking, as far as I know, all have gone the exclusive representation model, which is based off the federal model.
We're almost out of time. We're running a little bit late because we started a little bit late because the panel before us ran a little bit late. So any other questions? No more questions? All right.
Thank you.
Oh, did you have one, sir? Oh, all right. Well, thank you so much for attending, and we have a wine reception at 5 o'clock now upstairs near the registration table, and we'd love if you would all join us there. Thank you.